Hi, very good morning. Another interesting case Supreme Court judgment Greater Noida Industrial Development Authority versus Prabhajit Singh Soni under the Insolvency and Bankruptcy Code. Facts, as usual, facts are very, very important for a case. So, I will give it in very brief the facts. The appellant, that is Greater Noida Industrial Development Authority, hereafter he will be referred to as appellant. Appellant acquired land for setting up an urban and industrial township. One of the plot was allotted by way of lease for 90-year lease to one construction company. Hereafter, this construction company will be called as corporate debtor. It was given for a residential project, and the payment has to be made in installments. The corporate debtor committed default in payment, so the appellant served with cancellation come demand notice. Then he filed a petition against the corporate debtor for initiating corporate insolvency resolution process. That application was admitted by NCLT and claims were invited through public announcement. Pursuant to that notice, the appellant submitted its claim as a financial creditor for rupees 43 crores approximately. Let us not get into details of 43 crore, 25 lakh, 22,222.2. That is not the intent. 43 crores. RP, that is the resolution professional, treated the appellant as operational creditor. See, the claim was submitted as financial creditor by the appellant. Resolution professional said, "Arey, yeah, you are not a financial creditor, you are operational creditor. So you submit your form as operational creditor." There are two different forms, one for operational creditor and one for financial creditor. This fellow submitted its claim as financial creditor. Resolution professional said, "Arey, you submit as operational creditor." Appellant did not submit. No, no. He said, "I am only an operational creditor, so I will put my claim as operational creditor only." So, in the meantime, what happened was the COC meetings were held. No notice was served to this person, this appellant, and COC approved a plan and was presented to adjudicating authority, that is NCLT, for approval. NCLT also approved the same. On getting information, the appellant filed the IA questioning the approval. Decision of the RP to treat appellant as a operational creditor and all action taken in pursuant to those decisions. He also filed another IA to recall the order of the NCLT. The appellant pleaded, he submitted before the NCLT that there was gross error on the part of the resolution professional in treating the appellant as operational creditor. The second submission was resolution plan states that the appellant did not submit any claim because that resolution professional said you submit yourself as a operational creditor, you have submitted as a financial creditor. When he submitted the document, he did not even consider. He said there is no claim. So the third submission was appellant being owner of the land, because the land belongs to him, with statutory charge over assets. The appellant ought to have been given priority for its dues as secured creditor. Then fourth is no opportunity of hearing was given by the COC, naturally, because they did not consider this claim. The resolution professional did not consider this claim. NCLT rejected the application on the ground that despite lapse of 7 months between date of filing and approval of the plan, appellant took no steps against the resolution professional for not taking a decision on its claim. So now the appellant filed another appeal before NCLAT. That was also rejected. Now an appeal was filed before the Supreme Court. Supreme Court noted that operational creditor has to submit his claim in Form B. whereas financial creditor has to submit claim in Form C. There could be a situation where the claimant, in good faith, because he himself analyzes, in his good faith, may place itself in a category to which it does not belong. However, what is important is the claim submitted must be with the proof. The form in which the claim is submitted is directory and not mandatory. Supreme Court observed what is clear from the provision is that resolution professional is under a statutory obligation to collate the data obtained from one, claims made before it, and two, information gathered from the records, including the records maintained by the corporate debtor. If a claim is submitted by a operational creditor as financial creditor, vice versa, the claim would have to be accorded due consideration in the category to which it belongs, provided it is verifiable. And Supreme Court says it relied on J.P. Kensington. That is the case. It relies on that and says the adjudicating authority and appellate authority has limited jurisdiction in the matter of approval of resolution plan. There is no scope for interference with the commercial aspects of the decision of the COC. This is the preliminary view of the Supreme Court. Then the questions before the Supreme Court was whether the adjudicating authority has power to recall its order, because one of the application IA that the appellant filed before the NCLT was to recall its own order. That was rejected by the NCLT. So the first question before the Supreme Court was whether adjudicating authority has power to recall its order. The second question was whether the application for recall of order was time barred. Then the third question was whether the resolution plan put forth by the resolution applicant did not meet the requirement of section 32. Fourth is what is the relief to be given. These are the four questions. When it comes to recall application, whether it is maintainable, Supreme Court says the law is that a tribunal or a court is invested with such ancillary or incidental powers as may be necessary to discharge its functions effectively for the purpose of doing justice between the parties. And in the absence of a statutory prohibition in an appropriate case, it can recall its order in exercise of such an ancillary or incidental powers. This power must be exercised sparingly and not as a tool to rehear the matter. Ordinarily, an application for recall of order is maintainable on limited grounds. What are the grounds also? They have specified. One is order is without jurisdiction. Two, party agreed with the order is not served with the notice of the proceedings in which the order under recall has been passed. And three, the order has been obtained by misrepresentation of facts or by playing fraud on the court or tribunal, resulting in gross failure of justice. In the present case, the recall application was filed on the grounds appellant was not informed of the meetings of COC. Proceedings up to the stage of resolution plan was ex parte. RP misrepresented that the appellant did not submit any claim. And gross mistake on the part of the adjudicating authority in approving the plan. Supreme Court held that on the above grounds, the recall application is maintainable. So the sum and substance of the judgment is the tribunal or court, in the absence of a statutory prohibition in this act itself, can exercise the powers. It need not be specially conferred by the act. Inherently, it is available with the court or the tribunal, and they can exercise that power to recall the order, but it should be used, that power should be used sparingly. That is what the Supreme Court said. And in this case, all the more because of the facts, the Supreme Court said the NCLT had the power to recall its order. That is one. The second question, The Supreme Court said that whether it is within limitation, Supreme Court said it is within limitation. Then third, whether the resolution plan meet the requirement of section 32 of IBC. Supreme Court held resolution plan did not meet the requirement of section 32 on the following grounds. One, appellant did submit a claim even though as financial creditor instead of operational creditor. Form in which a claim is to be submitted is directory and not mandatory. Already we said this. Resolution plan did not acknowledge the claim made, but also shown an erroneous figure of rupees 13 crores instead of rupees 43 crores. It affected the right of the appellant in getting notice of meeting of COC because he did not get any notice, the appellant. That is point number one. Point number two, resolution plan did not place the appellant in the category of secured creditor because of which a charge was created on the assets of the CD. Non-placement of appellant in the class of secured creditor affected its interest. This is the second point. Third is very important. The plan conceived utilization of land owned by the appellant because this land belongs to the appellant. Ordinarily, feasibility and viability of a plan or economic wisdom of COC. So courts will not interfere. COC, whatever decision they are taking, the court will approve. But the feasibility of the plan has to be checked by the court. However, Supreme Court says, where the plan envisages use of land not owned by the corporate debtor, but owned by a third party. In the present case, it is by a statutory body. There has to be closer examination of the plan's feasibility. Corporate debtor did not pay installments, resulting in cancellation notice. The order of the authority does not envisage approval of the statutory authority, which is an important aspect of feasibility of the plan. So that was not taken into account by the NCLT. Hence, it is not meeting the requirement of section 32. That is the third question. Then the final one is, what is the relief? The Supreme Court set aside the orders of the NCLT and the NCLAT and sent the resolution plan back to the COC for resubmission after satisfying the parameters set out by the court and by the Supreme Court. That is what the judgment says. So very interesting judgment. Thank you very much. Have a great day.